Law is Order, Episode 2. Article 6, Supreme Law. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Art. v.1 Overview of Article 6, Supreme Law. Article 6 of the United States Constitution provides that the Constitution, laws of the United States, and treaties made under the United States shall all be the supreme laws of the land. This article also explicitly states that any laws of a state that may conflict with these laws will be deemed invalid and subordinate to the federal laws. This provision of the Constitution is important as it ensures that state governments cannot pass laws that violate the Constitution and other federal laws. Furthermore, this provision helps ensure uniformity in law throughout the United States by keeping states from having different laws that conflict with each other. Therefore, this provision serves as the foundation for one of the foundational principles of the U.S. Constitution and protects the sanctity of the nation's laws. Clause 1. Obligations of new federal government. The new federal government shall observe the following obligations. 1. Respect the fundamental human rights and freedoms of its citizens. 2. Uphold the rule of law, including due process and individual liberty, and protect them from any form of abuse. 3. Exercise its functions in the service of its people and their welfare. 4. Establish and maintain a transparent and accountable system of governance, including efficient and effective public administration. 5. Provide adequate social security, health care, education, and other public services. 6. Promote gender equality and support women's rights. 7. Enforce a fair taxation system and establish an independent budget office. 8. Ensure the protection of the environment. 9. Cooperate in an open and cooperative manner with international and non-governmental organizations, including promoting international peace and security. 10. Exercise effective fiscal discipline, in particular refraining from any form of wasteful expenditure, and ensure that public finances are managed efficiently and transparently. Art. vi. C. 1.1 Debts and Engagements Clause. Article 6, Clause 1. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Clause 2 Supremacy Clause. Article 6, Clause thereof, Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Art. vi. C. 2.1 Overview of Supremacy Clause. Article 6, Clause 2. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The Supremacy Clause, found in Article 6, Clause 2 of the U.S. Constitution, establishes that the federal Constitution, acts of the federal legislature passed in pursuance of the Constitution, and treaties ratified by the federal government are the supreme law of the land. Any legislation that the individual states enact that conflicts with this clause is invalid and preempted. The clause also requires all judges and officials to swear an oath of office, declaring their constitutional duty to uphold both the U.S. Constitution and any applicable treaties. The Supremacy Clause is one of the heartbeats of the United States Constitution and ensures that the federal government sets the law of the land. This clause helps maintain the supremacy of federal laws and preserves the unity of the country and its individual states. This clause ensures that individual states cannot pass laws that could conflict with or override federal laws. It also means that the federal government controls when it comes to matters of defense, foreign affairs, and commerce. This clause helps keep the nation united and prevents individual states from destabilizing. Art. vi. See 1.1 Debts and Engagements Clause. Article 6, Clause 1. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Clause 2, Supremacy Clause. Article 6, Clause 2. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The country. Art. V. See 2.2.1 Articles of Confederation and Supremacy of Federal Law. Article 6, Clause 2. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The Articles of Confederation, 1781 to 1799, established a government of limited and enumerated power, distributing ultimate sovereignty to the several states while granting Congress limited power to enter into agreements with foreign and domestic states. Article 6, Clause 2, of the U.S. Constitution replaced the Articles of Confederation by definitively establishing the supremacy of federal law over state law. This clause establishes the U.S. Constitution, laws passed pursuant to it, and treaties made under its authority as the supreme law of the land above state law. This means that if there is ever a conflict between federal law and the law of any individual state, then the federal law will be considered supreme. As a result, the U.S. Constitution, federal laws, and treaties made under its authority are essential for the legal framework within which state and federal courts operate and which the states must follow. The Supremacy Clause has been an integral part of the U.S. legal framework since its adoption, and it is a cornerstone of the country's legal system. It ensures that all states must abide by laws passed by Congress, treaties ratified by the Senate, and agreements made by the federal government with foreign nations. This helps to ensure that all Americans are treated equally under the law and that state governments do not pass laws in conflict with federal policy or international agreements. Art. V. See 2.2.2, Supremacy Clause and the Constitutional Convention. Article 6, Clause 2. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The Constitutional Convention of 1787 agreed upon and adopted the Supremacy Clause, which is a part of the United States Constitution. It was included in the finished version of the Constitution after much debate. The Supremacy Clause states that federal laws and treaties are the supreme laws of the land and supersede any laws or treaties of the states. This means that even if state laws attempt to contradict a federal law, the federal law will take precedence. The Supremacy Clause is the cornerstone of the U.S. government's balance of powers and provides the basis for rulings by the Supreme Court. It also outlines the federal government's power to preempt state law. The framers sought to stop any state from obtaining a doctrinal advantage over another. The Supremacy Clause serves as a reminder that the federal government is paramount in the system of national government, but it does not override the principle of state sovereignty. It does, however, provide a check against state legislatures making laws that conflict with the Constitution, federal legislation, or treaties. The Supremacy Clause lays out the framework of our government, and its relevance cannot be overstated. Art. V. See 2.2.3 Debate and Ratification of Supremacy Clause. Article 6, Clause 2. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Debate. The debate surrounding the ratification of the Supremacy Clause was important to the framing of the Constitution. The proponents of the Supremacy Clause argued that a uniform and binding constitution was necessary to maintain order and protect the rights of citizens. If states were allowed to create their own laws that were non-uniform, it could allow a state to violate the rights of its citizens or those of other states. Opponents of the ratification argued that it threatened the sovereignty of the individual states and the powers they had under the Articles of Confederation. Ratification. The Supremacy Clause was ultimately ratified because it provided a structure that allowed a unified set of laws and decisions to be made while still maintaining the authority of the individual states. The federal government was given clear jurisdiction over laws relating to certain objects, such as taxes, and all laws created in pursuance of the Constitution were made the supreme law of the land. This ensured a clear line of responsibility between the states and the federal government, providing an important framework for the protection of citizens. This served to protect citizens from having their rights violated by the government or other citizens while still allowing individual states to retain their own governmental powers. The Supremacy Clause was a critical element of the Constitution that allowed for a unified government structure and laid the foundations of our modern system of government. Art v. C. 2.3.1 Early Doctrine on Supremacy Clause. Article 6, Clause 2. This Constitution, and the laws of the United States which shall be made in pursuance thereof. And all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby. Nothing in the Constitution or laws of any state to the contrary notwithstanding. In 1821, the Supreme Court developed an early doctrine on the Supremacy Clause in the case of Martin v. Hunter's lessee. In the decision, Chief Justice John Marshall declared that, the acts of the general government, as police laws, made in pursuance of the Constitution, form the supreme law of the land. The court interpreted this to mean that when the United States Constitution and the national laws conflict with the state constitution and the laws, the national laws must be followed. This has laid the groundwork for the current judicial precedent that federal law is superior to state law, and any state law that conflicts with the federal law is declared unconstitutional. Marshall also held that the Constitution should be interpreted in the same way throughout the country to avoid confusion. This has become the modern practice of judicial review, where Supreme Court justices evaluate whether laws are following the Constitution. The Supreme Court's decisions in the Martin v. Hunter's lessee case and other early cases set the blueprint for the modern assumption of federal supremacy over the states and laid the foundations for our current framework of constitutional law. Article 6, Clause 2 to 3.2 of the Constitution of the United States of America regards dual federalism in the late 19th and early 20th centuries as follows. Dual federalism refers to the allocation of government powers in the United States of America between the federal and state governments. Specifically, it suggests that the national and state governments possess distinct areas of jurisdiction, authority, and responsibility. During the late 19th and early 20th centuries, dual federalism characterized the American system of government. This period is also referred to as the era of laissez-faire, due to the Supreme Court's move toward protecting private property rights. This moved the federal government away from its role in welfare and toward its more traditional role of protecting property. State governments excelled in welfare roles that the federal government continually cut back on in terms of aid and regulation. Overall, during this era of dual federalism, government power was clearly and precisely divided. Essentially, dual federalism during the late 19th and early 20th centuries was a form of government that split power between the national and state governments. The federal government was mainly responsible for lawmaking and enforcement, while the state governments excelled in welfare roles and aid. The Supreme Court protected the rights of private property owners during the dual federalism era, which was also characterized by an increase in laissez-faire policies. Ultimately, this meant a greater division of responsibility and power between the two levels of government. Thanks for watching.